try to comment on the same. So this set of webinars are part of our discourse in preparation for International ADR Week that is scheduled for the 17th to the 21st of November this year. And what they aim to achieve is to open up these conversations that we're looking to target for the activities of the ADR Week. And what is very, very critical, very crucial about these topics is that it is the continuous engagement enhances knowledge, enhances sector-specific approach to dispute resolution. And as we know that third-party funding is one of, like some of one of the thresholds that international investors are looking at from in various jurisdictions to see how competitive your laws or competitive your practice of international arbitration is. So that makes this a very topical conversation. And mine is just to welcome our moderator, our panelists, and to everyone who's joining us on this call. As we engage in this discussion, feel free to continue engaging on the chat function, but I know our moderator has more information on that. So welcome to today's conversation, and we hope that you all enjoy. We will make more discussions or more comments moving forward towards the end of the call. Thank you, and welcome to our panelists and to our moderator. Asante.
Thank you so much, Jacquelin, for introducing the meeting. I'll be the moderator for today. My name is Colin Ndondo. I'm an associate member of the Chartered Institute of Arbitrators. I hold a degree in political science from the University of Nairobi and a degree in law from the University of Nairobi as well. My research paper at the University of Nairobi was on this very topic of issue on third-party funding, and it's something that I'm very passionate about. I'm also a trainee an advocate trainee at the Kenya School of Law, and I'm looking forward to joining the profession properly sometime next year. So with that, I'd just like to give you a very brief overview of what we shall be discussing today. Basically, our focus for today is on third-party funding. And basically, our discussions today on third-party funding, and close the door. Yeah, our topic today is on third-party funding, and for those who are unfamiliar with the concept of third-party funding, this is a subspecialty within alternative dispute resolution that deals with mechanism in which an interested funder or an independent funder funds an arbitration to its conclusion in the hope of having a share in the proceeds of a successful arbitration. So that's what it's all about. And the highlight of the topics that matter most in why this is such a relevant topic is because it deals with the principles of expanding access to justice and making Kenya a more competitive, attractive arbitration seat within the region. Yes, so it's also important because it will expose the audience to opportunities for young practitioners that may want to forge ahead a career in alternative resolution, and specifically third-party funding, which is an emerging subspecialty in the region. And so this topic is extremely timely. So it's not just about explaining the concepts of third-party funding per se, but
maybe Colin, sorry, before you continue, we seem to be receiving some bit of echo on your end. Is it maybe that you have two devices logged in, and maybe you can consider logging off from one so that at least it's a bit clear?
Let me see. No. I only have one. Okay, you can still hear the echo, right?
Colin, the last time I checked and I did comment, there was two there appear to be two devices. In fact, when I look now, there are two of you appearing on the forum. So maybe that's why there's
Okay.
that. Yeah. So maybe you want to select which.
Oh, yes. I see what you mean. Let me, I see what you mean. Just give me a minute. So just a minute, please.
Colin, maybe you can try it again. I see maybe the other device have been removed. You can
Yes,
check
it's
and
been
see.
removed. Yeah.
Okay.
Can you hear me better now?
It is very clear now.
All right, great.
Thank you.
So I was just in the process of introducing the topic. This is all going to be about third-party funding, which is a subspecialty within ADR, alternative dispute resolution. For those who are not familiar with ADR, with the third-party funding, it is a dispute. It's a dispute finance procedure that allows for an impecunious client to actually go through with proceedings in arbitration without having to bear the financial burden of the arbitration, which can be also quite costly. So this allows for access to justice, and this also allows for making arbitration more attractive as a dispute resolution mechanism. And one reason why this is such a timely topic is because we have an arbitration amendment bill in Parliament 2025, which proposes to include third-party funding under Section 39A of the bill into the space of arbitration in Kenya. Third-party funding is quite advanced in the global north. It's a multi-dollar billion industry, and it's also gaining a lot of traction within African jurisdictions. Nigeria, for one, has had a comprehensive legislative reform surrounding third-party funding and basically regulating the sector. South Africa as well has been in the business for quite a while. And these are some of the things this is just an introduction of what third-party funding is for those who are unfamiliar. And I hope that that brief introduction makes it a bit clearer to understand. So it's going to be a very structured conversation. We're going to have 5 topical questions that surround 5 key issues that surround third-party funding, and our panelists will be able to chime in and give their thoughts and views on the various topics. And then at the very end, so each question will take about 20 minutes to converse, and then at the end of which we shall have a question and answer session from the audience. So with that brief introduction, I would like to introduce the panelists. So the first, from the very most senior, we have JB Ohaga, who is a senior counsel of Kenya with about 34 years of experience in dispute resolution. He's the senior partner at 𝐔𝐿 Law, which is one of the biggest players in the legal profession within the region. And yes, he's got expertise in domestic and international cases. Practice focus areas are in banking, finance, tech, procurement, energy, and commercial. He's a chartered arbitrator and accredited mediator as well, and a member of the governing body of the International Council of Commercial Arbitration. He holds an LLM in international dispute resolution and an LLM in corporate governance. He sits on the boards of committees of several arbitration organizations, Most notably, he played a role as the chairperson of the National Steering Committee for formulation of the ADR policy in Kenya. So he's also served in the inaugural board of the Nairobi Center of International Arbitration for 8 years. So that's a wealth of experience. Next, our next panelist is FCS Jacquelin Waihenya, Emerita Chair. She's an advocate of the High Court with active practice since 1998, founder and managing partner of JWM Law, a highly accomplished dispute resolver with advanced competencies in governance, ADR, and international commercial law. She's a chartered arbitrator and a fellow of the Chartered Institute of Arbitrators, and the immediate past chair of the Chartered Institute of Arbitrators Kenya branch. She's also the current chairperson of the Institute of Chartered Secretaries and a fellow of the same institution. And then next we have David Onsare, who's also an advocate of the High Court and a fellow of the Chartered Institute of Arbitrators. He's the partner and head of dispute resolution for the Maina and Onsare Partners Advocates LLP. He's the current chair of the C.Arb Kenya Young Members Group, Kenya chapter. Is recognized as a highly accomplished and impactful ADR practitioner in 2024. So he acts as both counsel and arbitrator in a range of commercial, domestic, and cross-border disputes. He has growing interest in ESG-related arbitration and evolved in the evolving role of TPF, or third-party funding in Kenya. He's very, very involved in that as well. He's written extensively for peer review journals and holds an LLM in corporate and financial law. So that's our panel, and as you can tell, that's a very distinguished panel, and I look forward to some very, very serious engagements moving forward as we proceed our web. So, I would like to delve into the first question. This should take us about 20 minutes to converse. The lead in this question will be Senior Counsel J.M. Ohaga. And I'd like to ask you, Counsel, what does the legal landscape look like for TPF in Kenya? And as you address the question, perhaps you can give a legal and historical context of the thought of championship and maintenance and how it stands in the way of TPF development in the country. You may also address the risks of a bifurcated regime that distinguishes between third-party funding in international arbitration and third-party funding in domestic arbitration, as per the stipulations or the recommendations of Section 39A of the Arbitration Amendment Bill 2024. Yes, Counsel, thank you.
Thank you very much, Colin, and thank you for that kind introduction. And thank you to the Chartered Institute Kenya branch for allowing us to engage in this forum for what is clearly a very topical issue, one that I think is beginning to define a lot of seats, one that is aspirational for a seat like Kenya, which is seeking to propel itself as a desirable seat, both for investors who are looking to position themselves in this country and looking to see how their disputes will be resolved. And obviously, the whole question of third-party funding sits at the intersection between Article 159 of the Constitution, which requires courts to promote the use of ADR, and Article 47, which speaks to access to justice. And the reason it speaks to access to justice is because third-party funding has the ability to unlock greater participation in dispute resolution. Now, Colin, in your introduction, you said that it would be available to impecunious parties, but actually the reality is that it is not only impecunious parties who would avail themselves of the opportunities afforded by by third-party funding. Third-party funding has become, in many established jurisdictions, in many jurisdictions which are advanced and whose dispute resolution frameworks have embraced arbitration, has become available even to players who are considered as having significant financial resources. Because what it does is to enable parties also to share the risks of engaging in dispute resolution through arbitration, as well as to manage their balance sheets and to manage their cash flow. So it is not just impecunious parties that are able to participate in third-party funding. But to come back to your question, third-party funding has its origins in the old historical doctrines of Champati, which I'm sure most of you would be familiar with, where essentially a third party supports litigation in exchange for a share of the proceeds. And separate from that is the doctrine of maintenance, where a third party provides support to litigation in which they really have no interest. And these doctrines are rooted in common law and were basically designed to curb abuse of the court process, particularly by powerful sponsors who engage in vexatious litigation. I had the opportunity to, same as you, Colin, because you mentioned that this was your research paper. I did actually write about third-party funding for my LLM dissertation. And so being able to engage with it in practice is something that I welcome. Now, Kenya has not explicitly abolished those doctrines of Champati and maintenance. And whilst it is correct that the strict application of these doctrines has waned in modern legal systems, they may still be invoked to challenge the validity of third-party funding agreements, which are deemed abusive or which are deemed to be unethical or contrary to public policy. And this is because whilst the reality is, and I think if we all thought about it, we have, as advocates, and I assume that a majority of our audience is advocates, as advocates, we have engaged to a certain extent in Champati arrangements. When you agree to take on a client's brief to conclusion in the hope and expectation that when that client is successful in advancing its litigation, that you will be able to charge a premium on your legal fees rather than just what is dictated by the advocate's remuneration order, you are engaging in some form or the other of Champati. And obviously, you hope that you will not get caught by the strict provisions of the Advocates, the Advocates Act. Because under our Advocates Act, particularly sections 36 and 46, which regulate agreements for remuneration, you will see that contingency fee arrangements are prohibited. And there are decisions of the Court of Appeal and the High Court which avoided contingency fee-based arrangements. And those, therefore, are still considered contrary to public policy as well as to professional ethics. So that is the narrow road map that we have to navigate as a legal community beginning to embrace third-party funding. And whereas third-party funding is not itself a contingency fee arrangement per se, there is still a risk that courts or regulators or the Law Society may treat it as analogous to a contingency fee arrangement. And this might arise because of the control which funders might have on dispute processes, whether through litigation or through arbitration, from the profit sharing, which is at the core of third-party funding, by the influence over proceedings, which third-party funders may have. And this is especially so where the line between financial support and legal strategy influence also becomes blurred. And so therefore, we do need a complete reform in our statutory arrangements. And specifically under the Advocates Act, we do need to relook at the provisions relating to contingency fee arrangements so that it becomes clear that those have no impact on third-party funding arrangements. Otherwise, judges and other judicial officers who may not have a clear perception or clear understanding of what is involved may strike down those arrangements and may therefore make Kenya unattractive from the perspective of the introduction and the propulsion of third-party funding arrangements. Now, as you did mention, Colin, I had the privilege of chairing the task force or the National Steering Committee for the formulation of the ADR policy. And part of our mandate and part of the product from that task force is the Arbitration Amendment Bill, which has extensive proposed amendments to the Arbitration Act, including the introduction under Section 39A, which you mentioned, relating to third-party funding. We also have the Construction Adjudication Bill, and we have the Mediation Bill, all of which have recently undergone a public participation process and will shortly come before Parliament, I hope. Now, the language under Section 39A, which we formulated, says that for the avoidance of doubt, the provision of financial support by a third-party funder in arbitration proceedings shall not by itself constitute a contingency fee arrangement, champerty, or maintenance, provided that the funder does not exert substantial control over the conduct of the proceedings or compromise the independence of counsel. That would be the ideal language that would be used in that statutory framework, so that it is clear that there are guardrails in place in order to ensure that third-party funding is used ethically, is used professionally, and is used properly to unlock its full benefits. And so as we seek to modernize our legal framework in step with global trends and to promote Nairobi as a competitive arbitration seat, the proposal under that legislative framework is to have language which allows third-party funding. I know that there will be questions asked because we did specifically provide for third-party funding only in relation to international arbitration. And the reason for that is partly what I have explained, the fear that within the domestic arrangement, unless there were amendments to the Advocates Act, that there may be constructions and interpretations and jurisprudence which would strike down third-party funding arrangements based on the present language. And we hoped that within the international environment, that would not be the case, because then that would be free of Kenya's domestic public policy. So hopefully, Colin, in a very wordy and roundabout manner, I've answered some of the questions that you have sought to pose. Jackie was part of my task force, or part of the task force at for the formulation of the ADR policy, and hopefully she can weigh in and also deal with some of the questions that you've asked. Thank you very much.
Thank you very much, Senior Counsel, for that elaborate introduction and into the topic. I would at this point like to invite Jackie Waihenya perhaps to chime in and, having been with you in the steering committee, perhaps she can also speak about, how does this uncertainty affect advising clients on domestic disputes right now? Or on top of that, she can add any comments to what you've just presented, and we'll move on. Thank you, Jackie. The floor is yours.
Yes, thank you so much, moderator, this afternoon. Good afternoon to you all. It really is a pleasure to be able to speak to this question of unlocking disputes and specifically through third-party funding. And thank you, Senior Counsel, for recognizing the work that we did at the National Steering Committee and how we also ended up including third-party funding in the statute, the amendment to the Arbitration Act, which is currently pending as a bill. And we have already undertaken some public participation. And we are now in the good hands of our brothers and sisters over at Nairobi Center for International Arbitration, which is chaired by my namesake and good friend, Jacquelin Oyuyo. So TPF is an exciting area which maybe I could also even indicate that as Senior Counsel was writing his dissertation at Queen Mary University, I was his classmate, and we ended up completing these studies and being exposed to what was happening around the world about the same time. And he's gone on to be able to write papers on this. I've also written a paper myself in the in the journal, the ADR journal in 2021. That's about the time when we were studying the first steps and just getting exposed to third-party funding. So like Senior mentioned, third-party funding really just refers to another person who does not have an interest as a client in a particular party, and then they come in and they finance. So the key thing about third-party funding is the funding and the financing aspect of it. Now, a lot of things have emerged and have happened around the world, and I'm quite sure that we'll have an opportunity to speak to some of them, including the wins, and there have also been challenges that have been faced in the leading jurisdictions that have employed third-party funding. And with Nigeria being able to do something successfully, we are also trying to put something in place. What I might just want to caution anybody, because I'm speaking to the domestic sector, is that we haven't yet passed the law. So what we're saying is very aspirational, but because we happen to be within the space of arbitration, within the context of arbitration, arbitration is a cross-border practice. And as a practitioner, we tend to be able to incorporate some of the emerging areas faster than the pure litigation. So there is litigation funding agreements available for anyone who is practicing. They are used extensively in the United Kingdom. We don't use them here for the reason that we are still bound by the common law principles of charm party and maintenance. So in our context, and when you're advising anybody in Kenya, the first thing you tell them is that we have the Constitution. It talks about access to justice. It doesn't allow us to do or engage in third-party funding for litigation. It is possible for a client, and I think the key thing here is to think about the SME or the individual who has a good claim, but does not necessarily have the financial muscle to be able to carry it forward to fruition. So when we advise, the first thing you tell your clients is that in Kenya, we do not as yet have a clear statutory, neither do we have a judicial green light, because we have not challenged this question before our courts. So there is the real potential that even if we do engage, whether in arbitration or in litigation with third-party funding, then there is a possibility that the agreement with the third-party funder could be deemed an unlawful agreement given the frameworks of our law today. And this could expose both the clients and the lawyers to liability. However, the thinking around the world and the cases that have been determined also around the world, and I would want to just refer you to a case called 𝐷𝐻 versus Northcote. It's actually considered a landmark judgment. And this judgment, and this is a UK matter, we, like I said, we don't have any judicial interpretation in Kenya. But one of the things is one of the outcomes that give this case the impression of implicitly endorsing third-party funding, particularly in arbitration, is that it looks at what the financial situation of the parties is. The disclosure aspect is important, and when I say disclosure is what I mean is that there must be a lawyer, there must be his or her client, there must be the counterpart on the other side. So the party engaging in third-party funding must disclose and indicate that there is a third party who is financing and who has a financial interest in an arbitration that is ongoing. One of the questions or one of the issues that needs to be highlighted is that there could be a magnitude of costs and also interest. And the party who is adopting this approach to financing has absolutely no other alternative source of funding. Hence the justification from the public access to justice. For us, that would be Article 48 in our Constitution. And once that is disclosed, then the questions of legal privilege tend to become questions that would be considered, and they are questions of fact mostly. And ultimately, then what happens is that if there's a successful party, then the successful party will receive a final award in their favor. And sometimes, not always, but in the final award, even the arbitrator may or may not make reference to the presence of a third-party funder in the process. Typically, the funding agreement tends to be captured by, by legal privilege, and not necessarily mentioned, or the details are not necessarily revealed to the other party. So the parties who are engaging in the agreement know what is in there. It's just generally the disclosure that there is that sort of arrangement in place. There are some of the investment arbitrations that have involved Kenya that have used third-party funders. So I can't say that it is possible to have the third-party funding arrangement in place, even with matters that emanate from jurisdiction. The one thing that I think also needs to be emphasized to anybody engaging with third-party funding is that it is a no-fault arrangement, such that if the party does not succeed, then the third-party funder does not have any recourse to the party who has adopted the third-party funding approach. Anything that is damages-based really falls within this category, regardless of what it is called. But I would like to say that in Kenya, we have put it in place. It is aspirational. It has its challenges. There are many. And the key thing right now would be to say you need to cross your T's and dot your I's in the agreements pending the adoption. I think what I'm trying to say is that pending the enactment of a detailed statutory framework that would also cater for everybody's interest, so that they can be able to, everybody can be able to legitimately and realistically assess their the legal risks that are that may apply to them all. And when I say everybody, I mean the lawyers, the clients, the arbitrators. If it's going to end up in court, maybe what the judiciary is also going to say about it in the long run. So let me stop at that.
Thank you so much, Emerita, for that contribution. We've got about 5 minutes to the end of the first session, but in the meantime, I would like to throw a question to Councillor David Onsare. What are the risks? I mean, Section 39A of the Amendment Bill 2025 is proposing for there to be a restriction on third-party funding to international arbitration and not domestic arbitration. What would you say are the risks of a bifurcated regime in the future should the bill pass? Over to you, David.
Good afternoon, everyone. Good afternoon, Colin, my fellow panelists, Senior, Ohaga, Emerita, Waihenya. Good afternoon. To your question, Colin, I am actually one of the proponents of third-party funding to be extended insofar as domestic arbitration is concerned. In response to that question, I want to build on to what Senior Counsel has mentioned, by giving us the historical context of behind third-party funding, the public policy aspect of third-party funding, so far as the doctrines of champati and maintenance are concerned, and also the position behind how third-party funding has been presented in the bill. From where I sit, for the third-party funding to be legal, these doctrines, champati and maintenance, must be explicitly, for lack of a better term, cancelled out by a new law to be passed by Parliament. I think this has been mentioned by Senior Counsel Ohaga, through a process called legislative abrogation. Now, while this bill proposes to do this for international arbitration, it fails to do so for domestic arbitration. The result is that for these agreements concerning to apply concerning to a domestic case, the old rules of champati and maintenance still apply. This means, as mentioned again by Emerita Chair, that the contract becomes presumably unenforceable. This could mean again that a party could win their case using millions of shillings from a funder, and then their opponent, or even the winning party themselves, could go to court and argue that the funding agreement is illegal and void based on champati. A judge bound by existing law would likely agree. Now, this legal uncertainty is what your question is asking, where a funder risks losing their entire investment on a legal technicality, effectively chills the entire domestic dispute market, making it impossible to find local claims. Now, this gap has severe negative consequences for justice and commerce in Kenya. It is not a theoretical problem, but it creates real-world injustice and economic inefficiencies. One being the bifurcated system you mentioned. It establishes a two-tier system of justice. Now, the proposed law effectively creates two different sets of rules for two different groups of people, directly undermining the constitutional principles, as mentioned by my colleagues, of equal access to justice. Scenario A here is the international player. A large German multinational, this is just an example I have in mind, wins a contract to build a power plant in Kenya. A dispute arises with their Kenyan client because the German company is a foreign entity. The dispute qualifies as an international arbitration under the Arbitration Act, Kenya. They can approach a funder in London or Dubai, whatever jurisdiction, secure the funds to hire the best lawyers and experts and pursue their claim to conclusion. They have full access to justice. Scenario B is a local SME. A Kenyan-owned engineering firm from Nakuru is subcontracted by a large, powerful, Nairobi-based main contractor for the same power plant. The main contractor fails to pay this engineering firm a 50 million because both parties are Kenyan. This qualifies as domestic arbitration under the Act. Now, the Kenyan firm has a clear, and the citizen is identified as Kenyan. The Kenyan firm has a clear winnable case, but cannot afford the fees to fight this well-resourced giant. Now, when they approach a funder, they're told, your case might be excellent, but because it is domestic, our funding contract could be declared illegal in Kenya. The risk is uninsurable. We can't help you. The Kenyan SME is forced to accept a local settlement or face bankruptcy. Now, this is what I call the justice gap in action. The law provides a tool for the foreign entity that it explicitly denies for the local one, creating an equal playing field. The second consequence is, again, it deters capital investment in local businesses. Now, sophisticated funders are investment managers, private equity, funds, their primary job is usually to manage risk. Now, a legal risk is probably the worst kind because it is not predictable. Imagine a funder in London, their job is to invest their clients' monies in strong legal claims. They look at two potential cases in Kenya, each requiring a 20 million investment. Apologies for that. Each requiring a 20 million investment. Case A is international, with clear legal backing from the new act, from the new bill, that is, 39A of the Arbitration Amendment Bill. Case B is domestic, with the looming threat of Shampati challenge. Even if case B is legally stronger, the funder cannot justify investment. Why? As I mentioned earlier, because the judge could, at the very end of the case, tear up their contract, making the entire investment vanish. This isn't a commercial risk. It's a flaw, if I may call it that, in the legal system. The result, again, is another chilling effect, what I call a capital chill effect, where money that is ready and willing to be invested in supporting Kenyan businesses is actively turned away. And finally, it encourages costly and inefficient legal maneuvering. So this system, again, forces our businesses and lawyers to use a substantial amount of time and money trying to fit a square peg into a round hole. For instance, consider two Kenyan tech companies in a dispute over software contract. To access funding, their lawyers might be forced to construct a creative but flimsy argument that the case is international because the software is hosted on a server in Ireland. This would trigger a preliminary a long time, few months, just arguing over jurisdiction, which in turn, as we are all aware, the arbitration process is not cheap, will lead to costing a few millions of shillings just to argue about this question of jurisdiction. The time wasted and the parties' monies are wasted on procedural fiction, all because the law fails to provide a straightforward path for funding a legitimate domestic disputes. Colin, I think I've identified 3 from the top of my brain here as consequences. I don't know if my colleagues have something to add or to mention to that. Thank you.
Thank you, David. That was very clear and concise. For the sake of our time, I don't know if Senior Counsel, you seem to want to chime in, but we've reached the end of our 20-minute mark for the first question, and I would like us to proceed to the second question. But if you've got something to say very quickly, maybe in another 2 minutes, that's okay.
No, I think David has dealt quite comprehensively with the potential risks, and therefore, obviously, the potential for a provision like that to be struck down as being unconstitutional. Having said that, sitting from where we sat doing the drafting and trying to navigate the present landscape, we sought A, to introduce third-party funding, but B, to acknowledge the strictures that exist in a legislative framework that was not within our mandate to amend. So those are the narrow confines that we had to deal with. So that's what I would say, Colin. Thank you.
Thank you so much. Emerita Chair, you seem to want to say something?
Well, I don't want to engage extensively on this particular question. I just also wanted to mention now that Senior Counsel mentioned about the drafting process of the bills that we had. I chaired the committee that came up with the legislative proposals. And while we acknowledged the importance of recognizing third-party funding in Kenya, we felt that the best way we would be able to also respond to third-party funding as it emerged, because it's a really highly evolving area, was to provide for it in the proposed statute, and then also make room to make extensive regulations, but under that provision, so that in case we needed to repost, we would not have to go through the whole amendment process, but we'd be able to put regulations in place which could be amended easier through the hand of the Chief Justice, who is a responsible office under the Arbitration Act. So I think we are in for quite an interesting season where not only third-party funding, but many emerging areas, just to provide for them, create a foundation for them in law, and then also facilitate the creation or the enactment of an enabling framework through regulation. That's what I wanted to add.
Thank you so much, Emerita. Yeah, so we've come to the end of the first session for the first question. I think a lot of insights have come out of this. First of all, championship and maintenance will have to be dealt with from a from a legislative perspective if we're to move forward with third-party funding in the country. I'd like to thank the panelists for their contributions in this first session. And now I would like to go on to the second question. There are 5 questions in total, so now we're going into the second question. And I would like Emerita to perhaps take the lead on this. And what I would ask is the market ready with well-equipped lawyers and courts to handle disputes relating to third-party funding? So basically, if you can give like an on-the-ground perspective on what law firms and practitioners and arbitral institutions are doing to be able to handle disputes arising from third-party funding. Thank you so much. The floor is yours, Emerita.
Yes, thank you so much, our moderator. And what I would want to say, I'd like to approach this question of the on-the-ground perspective and in this way. From an aspirational perspective, we're actually very ready. Kenya is very receptive to all the emerging areas, especially this one, because most lawyers acknowledge that this is an area where they can be able to engage in within the context of international arbitration without having to worry about collecting their fees at the end of the day. So it's actually a very exciting area for many people who want to have their the financial aspect of any arbitration secured. It also builds in very well with the many questions and discussions we've had on the question, the perception that arbitration costs are pretty high. So this is what I'll say. For lawyers and practitioners, there's a lot of interest. I think what we need to do now is what we are doing, for instance, today, which is training, engaging on the subject, creating institutional knowledge, and then in addition to that, also through the arbitral institutions, with C.Arb Kenya, we already championed this area for the last 4 or 5 years, together with NCIA. What we haven't done is to come up with guidelines. I think that is an area we really ought to think through. And the guidelines, typically, when we look at the ICC, the LCIA, they tend to really err towards the aspect of disclosure, the question of admissibility of funding claims, and also to limit the extent of involvement of the funder. And then, other than that, there are practical questions. This is a marketing question. How do you find a funder, for instance? So we need to ask ourselves, where do we need to go? What are the funders looking for? Are you able to pitch your case to a funder? And then in the event that you're able to get a funder, then what questions are you going to be asking? What demands are you going to be putting on the table to be included in your third-party funding agreement? Ethics and disclosure are a big deal. I'm not going to go into this right now because I know we have set aside some time to talk about ethical dilemmas and how we engage with them. But the questions we also need to ask ourselves is, well, when I do find a funder, what kind of due diligence should I be able to do? And then obviously the other issue is, as we are training practitioners, as we are training arbitrators, we also need to engage with one of our biggest stakeholders, that is the judiciary. How are they going to address any questions that may come out of third-party funding? The question itself on the third-party funding, are they going to lean on access to justice? What about the different scenarios? There will be questions about costs. Is there anything that will require to be addressed through security for costs, for instance? What about procedural fairness. How are we going to, how do we want to develop the jurisprudence in our country so that the necessary safeguards, the guardrails are in place, but then also that we are not chasing away potential funders who could enable us to really grow this area into an area that we can all really engage in with something to show for it in our pockets, because that's really what we want to come out of this process that we have. So what are we going to be thinking through? There's the legal contemplation. There's the question of the financial and commercial literacy. What is potentially can potentially be included in a third-party funding agreement? There are interesting costing models that are used by third-party funders. Are we competent? Are we able to argue for one? Because there are those models that use time. There are those that use costs. Which one are we going to look at, and how are we also going to be able to calculate the time that we required? What of course will go into legal fees? Is it expert costs? Is it arbitrator costs? Are there any other costs that will be there? We will be able to demonstrate what is a return of investment. I'm not sure whether I'm speaking of a.
We're losing you, Emerita Chair.
Yes, I can hear somebody in the background, so I would be quiet to let them speak so that I could just make my final point, which is when we engage with the question of third-party funders, an interesting aspect also tends to bring itself into the room. It's like the elephant in the room. How about the negotiation skills that the lawyers, the counsel, the parties particularly will require to be able to enhance? We have to grow these skills. We may not necessarily have them, because what are you, as counsel, what are you arguing for in a third-party funding arrangement? You want to have control over your case. It may be lost if your funder, who is controlling the purse strings, makes demands on you that maybe you're not able to agree upon. What about the client? Are they able to veto the final settlement? This is an issue that I came across within the context of international arbitration, where there are clients who wanted to settle, but the third-party funder said, no, you can actually get more out of this particular case. So if you are a little bit more aggressive, so that's sort of the things that would then create a problem for the party who wanted to settle. If you provide a little bit more time, they might come through and we settle for a bigger number, because at the end of the day, the funder is looking for a bigger amount through the percentage that is theirs. So all these skills will need to put them in place so that we're able to meet the space from a marketing perspective that will actually bring the money and leave it in our pockets. Because sometimes we tend to bring in, we call them FDIs, and the money comes, but the money also tends to remain in other jurisdictions. So those are the questions that we want to bring into place. And then obviously the creation of policy that will also protect the Kenyan lawyers, that will protect Kenyan clients, so that third-party funding can make sense at the end of the day. So we can look at training for third-party funding structuring, the questions of finance modeling, and also just expanding our market knowledge on how third-party funding and also damage-based agreements are enforced in other parts of the world. So I think I can probably stop at that and encourage our members to continue being, we're calling it, this is the thing that we need to do. We need to be multidisciplinary professionals, because at this point, when you're getting in third-party funding, you need to be first, maybe a lawyer. Secondly, you also need to have financial analyst skills. You also need to be a strategist to be able to acquire the best deal for yourself and for your client. We also need to put in place and develop for our own selves negotiation skills. All those will be required by anybody, any counsel, even a client, it could be a matter that you could be on the client seat if you're an in-house counsel. So please remember, you need to have legal skills, financial skills, you need to have corporate governance skills. You also need to be a great negotiator. This is all part of the whole package of being a good marketer. Thank you.
Thank you so much, Emerita Chair. Very insightful indeed. Just to tie into that question, I would like to perhaps ask Council David Onsare to provide the audience with an international benchmark while highlighting key lessons that Kenya can learn from them. Over to you, David.
Thank you, Colin. Thank you very much. I identified four jurisdictions that we can look at comparatively and focus on the best practices here and our learnings from them. I have identified Singapore, 1, England and Wales, 2, Australia and South Africa for proximity purposes. Now, for Singapore, I like to refer to them as the model for legislative efficiency. They were faced with the same historical doctrines we have mentioned earlier, champati and maintenance. Singapore acted decisively to bolster its status as a premier global arbitration hub. Now, this was done through their, what they call a Civil Law Amendment Act 2017. In this act, they created a clear and targeted statutory carve-out, explicitly abolishing the doctrines of champati and maintenance for international arbitration.
Sorry to interrupt.
Sorry, can you hear me?
Yeah, we can hear you. There seems to be some music in the background. I don't know if you can hear it.
No,
it's gone.
It's not from mine.
All right, it's fine now.
Apologies for that. At what point did you lose me? The Amendment Act?
Yes. You are Singapore.
Yes.
As the model
Now,
of legislative efficiency.
Okay, very well. Well, Singapore was faced with the same challenge with the doctrines we mentioned, champati and maintenance. However, they acted decisively to bolster their status as a premier global arbitration hub. We're still playing catch-up. Now, through this law, the Civil Law Amendment Act 2017, they created a clear and targeted statutory cover, explicitly abolishing these doctrines for international arbitration and its related court proceedings, such as enforcement actions. This move was, from what I read, was swift, unambiguous, and comprehensive. Our lesson here is clear as Kenya, that legislative speed and clarity are paramount to building confidence and attracting international capital. We can see how far they have gone from 2017, after this Amendment Act, to now. They have cemented their place as a global and very attractive arbitration hub. Second jurisdiction is England and Wales looked at together. Here is where we get the cautionary tale of imprecise drafting from their experience. Now, the UK's journey provides a serious warning to us. There's a decision here, as the recent Supreme Court decision, that is Parker, P-A-C-C-A-R, Parker versus Competition Appeal Tribunal 2023. I usually like calling it the Parker case. Now, this decision caused a serious shock in the funding market. Here, the court held that funding agreements where the funder's return was based on a percentage of damages recovered fell within the statutory definition of DBAs, damages-based agreement. Because these funding agreements did not comply with the strict regulations governing DBAs, they have regulations governing damages-based agreements. They were deemed unenforceable overnight. You can only imagine the effect of this decision insofar as funding agreements are concerned. Again, our lesson here as a country is that we must pay a lot of attention to precision in drafting, in legislative drafting. Any new law must define what a third-party funding agreement is, ensuring it does not get captured by pre-existing and potentially conflicting regulatory regimes like our own Advocates Act, rules on remuneration, and the sections Senior Ohaga mentioned. I don't think we can actualize TPF without subsequent amendments to the Advocates Act. The third jurisdiction is Australia. Here now we get the limits of a judge-led process. Australia initially liberalized its market through the judiciary. Most notably, we have a decision here. Campbell Cash and Carey Pty Limited versus Forstiff Pty Limited 2006. Here the court ruled that funding was not an abuse of process or contrary to public policy, provided the funder did not exert undue control. Now, how you confirm whether or not the funder exerted undue control is up in the air. While this opened the door, it also led to years of satellite litigation over the specific terms and limits of funding agreements. It's from this decision and the position taken in Australia, we learned that while judicial support is commendable, is important, is beneficial and necessary, relying on it alone creates uncertainty. That is why we need clear legislative framework from the outset. This gives us a superior path to establishing market stability. And finally, for South Africa here, our regional peers, theirs is the focus on regulating conduct. Their approach is highly relevant. Their courts have taken a public policy now approach, quite different to what was taken by the other jurisdictions, finding that funding agreements are permissible so long as they are not exploitative and do not cede control, excessive control of the process to the funder. This is a case-by-case analysis of the fairness of the agreement, what they usually call the standard of the reasonable man. Again, here, our lesson is that legalizing third-party funding is only half the battle. We've not won the war. The legislative carve-out must be paired with strong ethical guidelines from professional bodies and institutions to regulate the conduct of funders and protect claimants from predatory agreements. Colin, I think that answers your question. I've looked at the 4 jurisdictions.
It does indeed.
Just to see what we can learn from them.
Yeah, it does indeed. And I think Kenya can really learn, especially from South Africa, who are our peers. I think we can learn a lot from how they've maneuvered the issue of third-party funding throughout the years. So perhaps the final question for this particular session, I would like to ask Senior Counsel, is that with a focus on the judicial perspective, could you comment on the judiciary's capacity to handle complex third-party funding related applications? Maybe you can also add on to that by commenting on whether the judiciary as it is right now is receptive to accepting third-party funding as a viable, means of accessing justice. Thank you, Counsel. Over to you.
Thank you very much, Colin. Thank you very much, David and Jackie, for setting that background. My comment before I answer your question, my comment with respect to our readiness is informed by a comment or feedback that I got when I attended London Disputes Week last year. And I was asked to speak about the proposed legislative initiatives across the continent of Africa in relation to arbitration. And one of the reforms that I spoke about with much enthusiasm was Nigeria and Kenya proposing to introduce third-party funding. Well, after I finished, one of my English friends said to me, "That's all very nice, but be careful what you wish for." And I said, "Well, why?" And he said, "Well, the sheer amount of work involved is something that we have not contemplated. Because the reality is this, the reality is that once you introduce third-party funding, the funders will require legal advice. The funders will obviously be approached by law firms or parties who want to benefit from third-party funding. Those proposed or those seeking funding will require their advocates to put forward proposals which address all the legal issues arising in that dispute. And that involves literally preparing for the entire arbitration. The funders' advocates are required to advise the funders as to the veracity of the claim, the prospects of success, beyond the prospects of success, the question of enforceability of the award, the identity of potential arbitrators, the philosophy of those arbitrators, the obstacles to enforcement, the location of assets. So the work involved is actually literally the amount of work that you would require to do in order to advance your full case before the tribunal. And this work is for funders' advocates and for claimants' advocates. And what he said to me is for every 10 proposals that they have reviewed, funders only eventually take one. So what you're essentially doing is all this front-loaded work that you undertake for your clients in preparation for advancing your course, but the traction is very, very slow, very, very limited. Beyond that, the sort of skill set that you require is a completely different skill set. You don't require skill set only in relation to being able to advance the legal arguments. You must have damages experts being able to advise as to potential damages that could be recovered. You must have investigators advising as to location of assets, the ability to attach those assets, their evaluations, and so on and so forth. And so my answer is we are not ready. However, we must start on that journey. And we can only start on that journey once the framework is in place and once we are able to grapple with the challenges that third-party funding offers. And if we're not ready as a market, I think, Colin, you will appreciate when I tell you the judiciary cannot be ready. It cannot be ready because we have no jurisprudence around third-party funding in this jurisdiction. There might be jurisprudence that we can borrow from other jurisdictions, but third-party funding itself as a concept throws up so many complexities beyond the funding itself, beyond issues such as whether or not a funder should be joined to the actual dispute as a party, beyond issues relating to security for costs, the enforcement of those security for costs, the disclosure as to whether a party is funded, the questions that will then arise as to whether in fact funders have potential relationships with arbitrators, which may not be evident at the point when arbitrators are selected, because arbitrators are also in the marketplace, Colin. I sit here as arbitrator, but I also do counsel work. I act for various financial institutions. At the point where I am making disclosure to parties who seek to appoint me to a panel or a sole arbitrator, I have no knowledge as to what is happening in the background with them sourcing funders. It may very well be that they eventually decide that equity will be their funder. And suddenly I'm confronted with a situation where equity is also my client, and I accepted appointment to be sole arbitrator in that arbitration. You can see the amount of time that may have been wasted through my appointment and my eventual exit, hopefully, if I am sufficiently persuaded that I should disclose this relationship and that I should therefore stand down as being arbitrator. So the judiciary is not ready. There are many complexities that arise with funding. There are questions of control. How much control should a funder exert? And how can the question of that control be litigated? What is the balance between a claimant's advocate and a funder's legal representation? The question of strategy to be adopted in advancing a cause. And a funder, because it is an investor, may have a different strategy from the claimant's legal representation, and so on and so forth. And I think that with David having taken us through some of the decisions that have emerged from the markets which are more advanced in having adopted and embraced and litigated third-party funding, you will see that it will take a considerable period of time before jurisprudence actually settles relating to third-party funding. The first thing is to deal with our legislative framework. At the present time, we have no legislative framework in place. The second thing is to deal with training both for our legal market, training for our financial market, because you will also appreciate that our financial ecosystem right now is unfamiliar with third-party funding as an asset class. So they will also have to grapple with what it is involved. They're not specialists in the legal environment. And there will be the question whether Kenya is an attractive market for them. And so it isn't just a question of whether our legal market is ready, whether the judiciary is ready. It is also a question of our entire enforcement framework. Is it ready? I see that my friend Alex Masika is on the platform. Alex and I are involved in a very high-stakes arbitration in which I am leading the claimant's case. We have a large award in favor of the claimant, which we have been unable to enforce for the last 8 years. And that was a considerable disincentive for the funder that our client approached, because the funder recognized the existence and the veracity and the strength of the claim, but the ability to enforce, the time it would take, and the potential obstacles was simply a disincentive for the funder, and the funder walked away, notwithstanding that the funder recognized that there was a very, very good case for funding. So the long and short of what I'm saying is that we need to get on that road. We need to begin to take baby steps. We will learn through the process. There will be shocks to our judicial system as well as our financial markets. And I cannot say at any stage that we can declare a readiness until we've embarked on that journey. Thanks, Colin.
Thank you so much, Senior, for that explanation. I would like us to, I think time is not really on our side. We are running short of time, so I think we could go on to the next question. And in this question, I would like Council David Onsare to take the lead. And the question is this: how can adopting TPF position Kenya as a hub for resolving disputes in high growth sectors such as ESG and investment arbitration? If you can take the shortest time on this, David, that would be great for the interests of time. The floor is yours.
Thank you, Colin. I'll try. Again, thank you very much to Senior Counsel Ohaga for that explainer. Just to respond to your question, for us to understand our position, Kenya's position, we must think of international arbitration as a global marketplace where countries compete for the business of justice. Who offers the best business of justice? Parties to large international contracts do not have to resolve their disputes in their countries where the project is located. They can choose a neutral, reliable, and efficient location, an arbitral seat, what we call an arbitral seat, anywhere in the country, anywhere in the world. So in this marketplace, Nairobi is competing on multiple fronts. Regionally, we are here competing with Johannesburg, Lagos, Kigali, with a strong reputation for efficiency and government support. Mauritius, on its own right, established itself as a premier offshore financial center with modern arbitration laws. Globally, we're playing catch up to the likes of London, Paris, Geneva, Singapore, and Hong Kong as the traditional powerhouses. So in this context, TPF, third-party funding here, is no longer a niche or innovative product. It has become a standard expected feature of any serious arbitration hub. Much like a modern international airport is expected to have Wi-Fi and business lounges. For us to even be in this conversation, embracing third-party funding is a matter of competitive necessity. Failing to do so is like trying to compete as a taxi driver when you're not on these taxi hailing apps, the Ubers and the likes. You're just fighting a losing one. As I mentioned earlier, third-party funding, having it as an infrastructure is not enough to win. It just gets us on that table. It only gets us up to the starting line. The real opportunity here lies in using the framework to move just beyond just another option and becoming a strategic choice for specific high-value disputes. Now, this means developing what Emerita mentioned, especially some area of expertise. That makes now Nairobi, this would make now Nairobi the go-to destination for certain types of cases. So these high-value sectors, how do we unlock them? The third-party funding is a key now that unlocks this kind of disputes and unlocks the door to resolving these complex disputes that are vital to our vision. An example is infrastructure. As you're aware, we have a lot of infrastructure disputes in the country. I have an example here for you just to put it into context. Just imagine a consortium of, again, Kenyan engineers and construction firms. They complete a 5 billion road project for a government agency. The agency, however, fails to make the final 1 billion payment, citing budgetary cuts, budgetary issues. The consortium has a clear breach of contract claim, but the arbitration is expected to cost upwards of 150 million shillings in legal fees. It's an assumption, that's a figure. This includes expert witness reports, the engineers, quantum experts, and tribunal fees. No single company in the consortium has this amount of cash available without jeopardizing its payroll and ongoing operations. So without third-party funding, this claim, this meritorious 1 billion claim, dies, and the companies may even face insolvency. With third-party funding, on the other hand, a funder can provide this amount, these legal fees we've mentioned, in exchange for a share of the recovered amount. A clear pro-third-party funding stance. Of course, this third-party funding framework must regulate the extent to which the funder is to benefit from this arrangement. Now, with this framework for third-party funding, a funder can provide these sums in exchange for a share of the recovered amount, and a pro-third-party funding stance signals to all players in these capital-intensive sectors that Kenya has the sophisticated financial and legal infrastructure to see those disputes through to the end. Another one is the ESG arbitration disputes. TPF gives us a very unique opportunity to become a world leader in these disputes. ESG, that is environmental, social, and governance disputes, they stand for holding companies accountable for their impact on these three facets: the environment, social issues like community rights, and how they're governed. An example again, keep it very brief, Colin, just allow me to again contextualize this. A multinational corporation operates a large-scale agricultural project in a Kenyan county. Over 5 years, chemical runoff from the plantation contaminates the local river, which is the primary water source for 3,000 small-scale farmers and their families. Their crops fail, their livestock die, and people begin to suffer health problems. This community has a powerful claim for hundreds of millions of shillings in damages, but as individuals, again, they can't afford to sustain this claim. They can't afford to afford a lawyer, let alone the complex expert reports needed to prove the pollution came from the corporation. Here, third-party funding again is the only mechanism that can bring this case to life, level the playing field. Funder provides the capital to assemble the lawyers and the experts. By welcoming third-party funding for such cases, again, we brand ourselves as the premier seat for this kind of disputes, and also sends a powerful message to the world that Kenya is ready for business. Another area is investment arbitration capabilities. Also, third-party funding is, in my opinion, a game changer for disputes between investors and states, which are governed by BITs and international treaties. Colin, I don't want to add any more to that before you start telling me to stop there. I think that makes response to your question adequately.
Thank you so much. That was quite precise, quite concise actually. And just to tie into that question, a question that pops up is maybe I would ask Emerita to address this question. From a business development perspective, how can Kenyan law firms leverage a pro third-party funding environment to attract new international clients?
Yeah, thanks again. That is actually a very important question, and it speaks to our competitiveness as a jurisdiction. The first thing we need to do as Kenya is to think Kenyan. And when we think about a safe seat, because this is basically what we are discussing, C.Arb London published the centenary principles. And very quickly there, the legal framework, the judiciary, legal expertise. Even if you just think about the first three, we have quite a pool of competence in this area, not necessarily geared towards third-party funding, but at least when it comes to ADR. We are one of the leading ADR jurisdictions in Africa, at the very least, and we have been able to attract quite a bit of following and to attract quite a bit of attention from even the global north. The others are education, the right of representation. These are all provided for in our constitution, but we need to speak a little bit more about this because we know it. We know what our constitution provides. We know that we have the capacity. We know we have the people. We have, okay, I just wanted to refer to what Senior Counsel said about the judiciary and their preparedness. What I'd like to say is that as a jurisdiction, we have a very receptive judiciary. Even when they're not, they haven't dealt with the matter, they're always ready to investigate it and build jurisprudence in that area. So leveraging those relationships and leveraging the kind of judiciary that we have, I can tell you that we have also made waves in this way because of our Supreme Court having the fellows in the Supreme Court. And there are other practical considerations because there's accessibility and safety. Do we have the hotels, the facilities, the infrastructure? When it comes to access to the digital space, we have that. The areas that we probably want to consider a little bit more because there is a perception, and I'll call it a perception, because I know we can make it, we can deal with ethics and we can deal with ethics conclusively to the point where we are all very involved and engaged in ensuring integrity and ethics in our systems. Of course, the key issue is enforceability. We have the framework. We just need to bolster it a little bit more so that we can have enforceability as a given so that we don't have Senior Counsel saying the third-party funder walked away because they couldn't see how enforceability was going to, or how it was going to end up bringing the money into their pockets. And then the immunity of arbitrators. All these we have in our framework. I believe the most important thing that we need to do is to bolster them and then shout a little about it. Remember, we're an English-speaking country. We are a common law country, and we are able to build on the legal expertise, the legal framework. Law reform is a big deal. We've been working on it. We're probably slower than we ought to be, but if we're able to achieve the reform that we have purpose to do so, what the journey that we're walking right now, we're going to get a place to a place where we have a stable jurisdiction with capacity to handle not only third-party funding matters, but pretty much anything to do with ADR. So if I was to say, let's work on business development, a business development strategy for law firms, we start here by speaking the language of legal certainty, speaking about third-party funding and the nuances that go into third-party funding. We can only do that if we enhance our capacity and our ability to handle this. So it means deliberately educating ourselves. And not, when I say ourselves, I mean the whole legal fraternity, the whole legal community. That's the lawyers, and it also includes the judiciary. It also means that we need to work a little bit closer with our academies, that is the universities that are teaching, so that the students who are the natural products of the universities come out ready, TPF ready, speaking the language, understanding the nuances, being able to match the disciplinary requirements, so they can acquire financial skills, legal skills, and also be able to put all this into a way that can be digested by the consuming public, the law firms, and also when I say that we need to speak, we need to be thought leaders. The thought leaders will come out of our academies. They will come out of engagements like what we have. And if we are able to put together, and I'm going to underline, a cost-effective legal talent pool, then we'd already have laid a good foundation for business development in Kenya. For the law firms, will have a ready pool to draw from. They'll be able to also say, these are Kenyans, they're available here locally, they are affordable. I didn't say cheap, I said they're affordable. They're stable, they're English speaking, and we have a large pool of them. So we can say, look, there's no difference between us and London, there's no difference between us and Singapore. So we need to be very, very deliberate about that. And when we start talking, we tend to be very shy as Kenyans. And I can tell you, I have a great respect for the legal equity of the legal professionals in this country, and also the capacity, the breadth, the length and the breadth of the knowledge that they have. We need to be able to speak to power. And when I say speak to power now, I'm speaking about the global funders, so that we can engage with them on the material that they need to understand, but we speak to them from a local council position, because they're used to doing third-party funding in their country. The truth of the matter is Africa has a different dynamic altogether, and the only people who understand Africa are we Africans. So we need to be able to say, this is the theory, this is the practice, this is the reality in Africa, and we need to shout it loudly so that we can be able to offer specialized legal services that are responsive to the Kenyan situation. We tend to understand and appreciate what is happening in East Africa as well. So all the things that go into this, drafting and negotiating funding agreements, how do we do the cost and risk assessment? It's not the exact same thing that you find out there in the global north. What we have is different. You know how Kenyans like saying, kwa ground ni different. So we need to be able to sell that as the skill, because they don't have that, we have it. And then build our institutions so that they are strong. How do we build our institutions? Enhance the guidelines so that we stick to the question of obligations and the nuances that we will find, because as we move along, we will come and engage. We'll come across different interesting experiences. We must provide for that. And once we do, anytime we make any, we develop or we take a step, let us train our legal community so that we are up to date. When we do that, that value will speak for itself. It will speak to the foreign investors. It will speak to the multinational corporations. It will speak to the big business areas. You're talking about mining, oil and gas, PPPs, infrastructure, you name it. We are the Silicon Savannah of Africa. So when it comes to anything digital, even we will have an advantage on that. So when it comes to institutions, let's think regional. Let's build ourselves. In Kenya, we already have NCI and we have C.Arb. If we can collaborate instead of living in silos, which is what we tend to sometimes do, if we can collaborate, there is greater opportunity to shape our policy and to create a high growth sector for this space and even others. And we can target I think I want to call them the four key areas. ESG has been mentioned by David. So anything climate and ESG related disputes, remember we host UNEP. So we have a ready pool of experts when it comes to climate related anything, all the matters. Technology and IP, we are at the forefront. We are very well known, by the way, for being a top investor state arbitration nation. Our Attorney General has won pretty much all the cases that we've had. And let's talk about energy and infrastructure, the PPP, disputes, construction. Actually, the list is endless. But if we focus on those four areas, we'll be able to point at an area we can say, look at what we have done with what we have. Can you imagine the capacity of the Kenyans? They are very versatile. They have a very impressive legal equity. When it comes to policy and legal reform, they are right at the forefront. And I just think what we need to do is to engage with thought leadership and be able to have a demonstrable database that we can point to. If we have a database, then when it comes to artificial intelligence, whether we are talking about large language models or small language models, what we need to do is to be able to say, this is what we've got.
Emerita, are you there?
This is Kenyan, and you need to be here. Otherwise, the business.
5 minutes. So now, just one other question on that ties into that is I'd like to ask Senior Counsel Ohaga, how does TPF position Kenya strategically against other African jurisdictions as an arbitration seat, obviously?
It obviously, for all the reasons which Jackie has outlined, it would propel Kenya forward considerably as a forward-looking, attractive seat of arbitration. The reality is that there is greater and greater investment into Africa in all sorts of areas, whether it's infrastructure, manufacturing, technology, you name it. There is a growing interest in Africa. Africa has the potential to have the fastest growing economies. And everybody knows that. And so there is significant attention on Africa. However, there is a continuing competition by different jurisdictions to position themselves as jurisdictions that are most attractive for foreign direct investment. And so in my view, being able to embed third-party funding as part of our legal infrastructure would, without a doubt, mean that Kenya suddenly shoots, well, not necessarily to the top, because Nigeria already has third-party funding, and South Africa has third-party funding, but it would position us very, very well, make us very attractive, and also ensure that when parties are considering what seats to designate in their dispute resolution clauses, that Kenya will be at the very least on the list of those jurisdictions that are available for discussion. And I think those reasons have been outlined very comprehensively by both David and Jackie, and I needn't repeat them. I think, Colin, that's my straightforward answer to your question.
Thank you so much, Senior Counsel. Yeah, for the interest of time, I think we better move on to the fourth question. We've got one more question, and after that, we're going to have our Q&A session. Time is not really on our side, but I think we started a bit late, so we might push it a little bit to around 4:15. But Senior Counsel, I would like you to kindly take us through some of the ethical and procedural safeguards surrounding TPF. For example, disclosure versus privilege, founder claimant settlement conflicts, If you could discuss arbitrator independence as well, and other principles that must be protected, especially regarding disclosure. Over to you, Senior Counsel.
That's interesting, and I think I already touched on some of that when I spoke a little earlier.
Okay.
Third-party funding is a minefield so far as ethical considerations are concerned. And it is a minefield both with respect to the funders, with respect to claimants, and with respect to the tribunal. Starting first and foremost with claimants, and of course for respondents as well, because respondents defending claims have an interest eventually in ensuring that if they're successful, that they will recover their costs. And the question that then arises is, if a claimant is funded, can you look beyond the claimant and enforce your award of costs against a funder? So there are many ethical issues that arise. The first and foremost ethical issue is for whether a claimant should disclose that it is funded. And I think that when we do get to framing regulations, that must be addressed. The existence and the identity of the funder, that is minimal and necessary. The next thing that we have to think about is actually the disclosure about the terms of the funding. Because when there is too much risk, that undermines legal privilege, it impacts case strategy, and even the negotiating leverage in the settlement. And that has the potential to impact the entire arbitral process. Then there are issues relating to funder versus claimant conflict. The funder has its commercial interests, and the claimant wants to make decisions about the trajectory and the conduct of its own case. Then there are conflicts or potential conflicts relating to a disclosure for tribunals. At the point when parties determine that they will have to go to arbitration and are appointing a tribunal, the question then has to be whether the claimant at that point should disclose to potential nominees for selection as arbitrator that it is being funded and who the funder is, so that potential arbitrators can make a decision as to whether or not to accept appointment, having regard not only to the identity of the claimant, but also to the identity of the funder, because that has its own inherent risks. And where funders come in midstream, that also has the potential to jeopardize the integrity of the tribunal in the event that the tribunal or a member of the tribunal has a relationship with a funder. So there are many integrity issues embedded in there. When it comes to settlement, funders' objective is to maximize the potential award in order to ensure that it gets full value plus more for its investment. It may very well be that a claimant's interest is in the end to bring the dispute to an end. A claimant and respondent in a commercial relationship may have had a relationship which they want to restore and which could be restored by a negotiated settlement, but those negotiations would be subject to approval by the funder. So some of the things that we say are inherent or are some of the benefits of arbitration then become blurred and become lost. Issues such as confidentiality also could be significantly impacted because funders may want insight into a case that they're considering funding, But in the end, they may end up rejecting or not taking up that case, but they have had insight, they have had access to documentation relating to both the claimant and the respondent. What are their obligations in that case? Are those obligations protected only by a non-disclosure agreement, or are there other considerations that come into play? And then the balance between the parties. Should funding be available also to respondents? And if funding is available to respondents, what should the considerations be? Should funders be able to take on only a certain number of cases? In fact, when I was interrogating the regulations around third-party funding, I believe it is either in Singapore or Hong Kong, there is a ceiling as to how many cases a funder can take on at the same time. Because it is also possible for a funder to go bust. Yeah? A funder could go bust if, for instance, the 3 matters that it took on conclude all at the same time, and are all adverse to the claimant, and the funder then has to pay out. But it may well be that there are other cases in the pipeline which this same funder took on, and for which this funder has obligations. And so in the same way that banks, insurance companies go bust, funders can also go bust. So there needs to be a regulatory framework around considering what are funder solvency levels, how are those determined, and yet at the same time, arbitration is a confidential process. So what visibility should regulators have about the number of cases that funders are taking on, the level of risk that they have taken on, and what commitments that they made in relation to each one of those cases, and so on and so forth. And so, Colin, because of the constraints of time, it is difficult to outline all of them. But I would conclude by saying that it is a minefield, and we need to think through every potential obstacle, every potential scenario in order to ensure that we have a comprehensive safeguard and regulatory framework. Thank you.
Thank you, Senior Counsel. Just to sort of push that question a bit further, I would like to ask our Emerita Chair this question. With regards to privilege, how do you navigate the tightrope between duty to the clients and the interests of the funders?
Okay, tightrope is the right word because there's a lot of tension. The first thing any lawyer should remind themselves is that they have a primary duty to their client, not to the funder. But in reality, the funder, because of their financial interest, they will want to receive a detailed case assessment from you. They will want to have access to strategic documents. They will want to have an input in making strategic settlement decisions. And sometimes this will mean whatever documents, your statement of claim, or if it's a counterclaim for the respondent, they want to have a say in that. And they also want to have a budgetary and a procedural update from you. So when you're the lawyer with a third-party funder, you're caught right in the middle of these discussions. And these are discussions ideally you should have with your client and not the funder. But the funder is the one who is going to be there critically asking you for documents on a day-to-day basis or on a regular basis. And this then calls into the question of privilege. Now, we tend to understand legal privilege from what we've learned as lawyers in a common law country like Kenya. What we need to understand is that legal privilege does not apply in the same way in different jurisdictions. The first key distinction is that with civil law jurisdictions, the question of privilege is actually, if you consider it from our point of view, is actually really watered down. So if you have a third-party funder who is from a civil law jurisdiction, there is a tendency for them to expect a great deal more. So you spend a lot of back and forth with the third-party funder, discussing on things which to you seem obvious. You're a common law country, and what we've seen being exposed to the common law of England, what we've seen from other common law jurisdictions like the United States is that the privileged communication, you might think of it as a strategic memo. If you have any kind of background from the United States, there's this thing they call work product. So anything that you're working on, you feel is privileged. So it's important for you to be able, first of all, to put in the third-party funding agreement what you will consider to be privileged, because if you also are not too careful, what may happen is that you may release documents to your third-party funder and then lose the right to invoke privilege because it's now outside of the realm of communication between a client and their advocate. So it's important, even if you're sending anything out of to the third-party funder, use non-disclosure agreement, what we call NDAs, and ensure that in the unlikely event, let's say unlikely event, that you do have to defend this in some other forum, it is a non-disclosure agreement that outlines a common interest or a joint defense should you have to defend these issues in a later forum. You could also use summarized documents or neutral documents or redacted, where you redact the privileged information. Redacted documents are very difficult to consume because of the way they look. And there's always that feeling that I'm not getting the full story. So it's probably better to err towards a side of summarized or neutral documents. And then on your part as legal counsel, ensure which do not necessarily have to be covered by legal privilege. Now, one key consideration that you need to have, in Kenya, it doesn't make any difference whether you're in-house counsel, whether you are a litigation counsel, then in some countries, including some common law countries, in-house counsel communication or general counsel communication, which is what they call it, is not privileged. So you also need to be careful what communication you are engaging in between you as a litigation counsel and general counsel. So privilege, by the way, is the key area where you must be very clear about what challenges can arise. And that is where you'll find some of the most challenging ethical dilemmas, because you, as a lawyer, you also have your own personal ethical boundaries, how you will deal with your client, how you will deal with any other funder. Now, if you want to take an example of a third party who may be involved in your case, but who is not necessarily your client but has the same dynamic as a third party funder, think about your investigators. You want them to get you some important information, and they may not, you actually reveal the information that you want to give them to equip them on a need-to-know basis. If the funder is controlling the funding or the financial aspect and they have a lot of influence over you, you may not be able to manage that. So it's important to ensure that your third-party funding agreement make the client advocate, your engagement is client advocate, and the client is a final determinant. And then also, if there are any areas of disputes, and they will arise, you have to expect them, then also ensure that you have protocols for a dispute escalation between the client and the funder. So you don't want to create another dispute while you're trying to resolve this particular dispute. And it's important to have a continuous discussion between the client and the funder and yourself, so that you're letting everybody know what needs to happen on a particular, say on a particular day or on a particular decision or question. And they also are able to respect the boundaries. You have to put in guardrails, and those guardrails must be observed. If you don't observe the guardrails, then the message you send to your third-party funder is that, okay, they're there. Maybe they're sort of a suggestion, you want to ensure that the guardrails are protected at all times, because at the end of the day, the person who will be exposed is you as the lawyer. So disclosure and confidentiality is one of the areas that you want to be very clear about. You will need to disclose to the arbitrator. And I would suggest that you do this. It's actually just best practice that you need to disclose that you have a third-party funder. You may not necessarily have to disclose who the third-party funder is, but depending on the institution, that information may also become necessary to disclose. So be careful about releasing sensitive financial or strategic information, including to your funder. And I think that the only other thing that I want to appreciate the jurisdictions that you're dealing with, and ensure that in your third-party funding contract, you have a conflict of laws clause, so that if there is a potential conflict, then you'll be able to sit and determine amongst yourselves which laws relating to legal privilege apply. Because there are 4 key types. There's legal advice privilege, so you can protect confidential communication between lawyers and clients. There's litigation privilege. I've mentioned that also. I mentioned the US and their work product doctrine. For civil law, they call it professional secrecy, but it is not as strong as what we have here in Kenya or in the common law. Understand that your seat of arbitration may have a different dynamic depending on which seat you put into the arbitration clause as the seat, which will also determine the applicable procedural rules, and it will also probably determine how the tribunal is going to handle the question of third-party funding and what the extent of their discretion, how many questions, to what depth can they ask those questions. So you want to be 100% sure that your seat, that you're conforming with the seat that you're provided for, and that you're not opening up your arbitration proceedings to much more, disclosure than you would ordinarily have had in the areas that you are more familiar with. So please, at the beginning, know who you're dealing with, know the jurisdictions, the seat, the law, appreciate the privilege rules right from the first management case management conference, and then be very careful when you're dealing with cross-border legal teams because of differing legal dynamics. Yeah, so I think I can rest on that.
Thank you so much, Emerita, for that very concise breakdown of the conflicts that may exist between funders and, well, yeah, between the tightrope between duty to the client and the interests of the funders. So now, one last question I'd like to ask David is what are some of the most notorious manifestations of funder claimant conflict?
Thank you, Colin. First, I would want to agree entirely with what SC mentioned when he was submitting on this question, that third-party funding is an ethical minefield. And without question, this conflict, the funder-claimant conflict, is, in my opinion, the most dangerous ethical minefield in TPF, in third-party funding, because it strikes at the heart of the relationship between the client, their advocate, and the funder. This conflict, the funder-claimant conflict, arises from a simple truth. While the claimant and the funder are partners on a journey, they have different destinations in mind. We have to get that clear. The claimant's destination is simple: justice and resolution. The funder's destination is specific: calculated financial return. It's a business opportunity. For most of the journey, these paths are parallel, but at the crucial intersection of a settlement offer, these paths can diverge sharply and dangerously. Just an example. So imagine here we have a construction company let's call them 𝐔𝐧𝐥𝐸 Limited. They completed a 200 million project, but the developers refused to pay again, citing baseless claims of defects. The dispute has been a nightmare for the company, sorry. They have remortgaged their homes to keep the business afloat and pay salaries, and the stress is immense. They have a clear, winnable case, but no money to fight. They secure funding from private equity firm, Capital Partners. Capital Partners agreed to invest 50 million shillings to cover all the legal fees and expert costs. Their funding agreement, which is standard for the industry, states that they're entitled to a return of 3 times their investment. That is 150 million shillings. If the case is successful, this isn't just greed, it's their business model. For every 9 cases they fund, several will lose, and they need the successful ones to generate enough returns to cover those losses and provide a profit for the investors. After 2 long, grueling years of arbitration, the developers' lawyers make a settlement offer of 100 million shillings. Now, we need to look at this offer from 3 perspectives. For the company, the 100 million is a lifeline. Remember the challenges I mentioned? It's a massive victory. It allows them to pay off all their debts, secures the employees' jobs, ends the sleepless nights, and saves the company their financial challenges. Their advocates, on the other hand, are bound by their professional duty. Reviews the risk of a final hearing where a win is likely but never guaranteed, and advises them that this is a reasonable offer. The company instructs the advocate, accept it, we want our lives back. Now, for the funder, the 100 million is not acceptable. Their financial model, as I mentioned, is clear. They invested 50 million, and their minimum return is 150 million, a settlement of 100 million. After their lawyers are paid and the company gets their share, means the funder might not even get the initial 50 million back. They have looked at the expert reports and believe that there is a 90% chance of winning the full 200 million in the final hearing. They want to roll the dice, take the gamble. Now, what is the trap here? The funding agreement contains a critical clause. The funded party may not accept any settlement offer without prior written consent of the funder. The funder, looking purely at the financial model, exercises their contractual right. They refuse to accept. So this is where now the ethical crisis, as C mentioned, explodes. The advocate is trapped in an impossible position, caught between 2 conflicting duties. On one hand, it's their duty, professional duty to their client. The client has given clear instructions to accept the settlement. On the other hand, the advocate knows that if they follow the instructions, their client will be in breach of the funding contract. So the funder will then sue the company for breach of contract, potentially claiming the entire 100 million settlement and more in damages. So what can counsel do? Advise the client to accept the offer and face a new suit from their own funder, that's one. Or advise the client to reject the offer they desperately want to accept, forcing them to continue with a stressful and risky arbitration for the sole benefit of the funder. This is the most complex ethical challenge because it pits the very purpose of third-party funding against the commercial engine that makes the funding possible. If funders cannot protect their investments from what they see as premature settlements, their business model collapses and they will stop funding cases. It's a delicate balance here. But if claimants are forced to seek control over the most important decision in their case, then the system is no longer serving justice, it is serving capital. This is why, in my opinion, I believe it is absolutely necessary for us to have a robust third-party funding framework or even guidelines. These guidelines must state, I think that is what 39A tried to do in passing. The clauses giving a funder absolute and qualified veto over settlement are unethical and contrary to public policy. They should also require that all funding agreements contain fair and reasonable mechanisms for resolving such deadlocks. Without these safeguards, we risk creating a system which, if unregulated, where the advocate is trapped and the client who came seeking justice ends up with a new master. We got a tool which we intend to balance the scales, improve access to justice being used to the detriment of those seeking to access justice. Back to you, Colin.
Thank you so much, David, for that concise explanation. We are at 4 o'clock now. We've got one more question to go. I would like the panel to just indulge me for another 10 minutes, and then we can go into the question and answer session. I don't know if that's okay with you guys.
Yes, it is.
Is it an area that we may already have covered? Because I know that in some of our answers have gone beyond.
Yes. So yes. So now for this particular question, it's for the young practitioners in the ADR field. What are some of the opportunities, the career opportunities that present themselves? And I think this has been touched on previously, but if we can just go over it for another 5 minutes and then do a question and answer and then finish, I think that would be great. So maybe Emerita Chair, if you could take the lead on that. You've spoken about it, but maybe you can just expand on it just a little bit for another 5 minutes.
Okay. Well, to the next generation, it may not be very readily apparent, but those of us who are your parents really wish we were living in a season such as yours, because there are so many emerging areas. And it may not seem that way, but very many areas of practice are opening up, and arbitration is no different, and particularly third-party funding. So if you have an interest in anything to do with law and dispute resolution, if you have capacity to understand financial work, if you are able to think strategically, then third-party funding is a niche that you would be very at home with. So it blends legal, financial, and strategic advisory work. It needs you to be very alive to what is happening around you. It's a fast-growing area, but if you enjoy reading, it's a very easy area to just build your skills in. You'll not find many of the things in third-party funding being taught in your classrooms. And what I would say is that if you can find any material on litigation finance, then you can be able to advise in this area. What you can expect to do in a career that is geared or leaning towards litigation finance advice is you probably expect to structure, negotiate, and review third-party funding agreements. And you can do this for both legal clients or even third-party funders as well. And you could also look at the different nuances between different jurisdictions around the continent. Because what applies in Kenya is not necessarily what's going to apply in Nigeria, but many third-party funders are looking for somebody who is African, and everybody assumes that Africa is a country we know better, but then that is an opportunity just waiting to happen for you if you equip yourself with the necessary skills. For dispute risks analysis, that's another area. To first of all see if claims are viable. Damages modeling is another area that is so interesting. Technical valuation approaches are evolving. They are different. Some they lean towards income approach to determine damages. Some also lean to a market approach. Some lead to a cost approach. Ask yourself what these questions mean and how they interact with the world of international arbitration. If you are tech inclined, understand artificial intelligence and agentic AI. What does this mean? Are there any challenges? How does technology present? Is it of any value? I will tell you for free that artificial intelligence and computing all these damages is an area that is definitely going to expand and grow. What about challenges to do with the climate change, energy transition, net zero? All these are areas that you can expect somebody is going to need some advice somewhere. So build your capacity in this area. If you can be able to come and do the modeling, how do we identify risk? How do we manage risk? How do we enforce risk management for funding approval? This is another area. If you're good at mediation and you're able to understand people, you have good people skills, you could be a funder client counsel, not a litigation counsel, but the kind of counsel who can run interference between those gladiators in suits and the finance guys in the financial environment, and then try and bring sense and strategy into what they need to do so that you can be able to manage expectations from both camps. Understand what is happening in different jurisdictions, what's happening in Uganda, what's happening in South Africa. Their models are different. Understand what a funder would want to know about those different jurisdictions. Be ready to sell what you have, and your ethics and disclosure. If you understand ethics and how to manage disclosure, this is another area that you could do very well. If you have the skills for portfolio, this is what you call project management. Look to build skills in this area, or if you have skills or potential or interest, actually interest is the real word, for legal reform and policy, these are also areas that you can also build yourself. Look for third-party funding specific knowledge. Our alma mater, that's mine, and senior counsel, Queen Mary, has done quite a bit of studies on this. There's a task force on third-party funding. Read what they have written. International Bar Association has also a few issues or documents that you can read. The ICC and SIAC, that's the Singapore Arbitration Center on third-party disclosure. Read the relevant cases. There is also quite a bit of material online. And then write. Please write. Don't be afraid of writing. Put it online. Put it in LinkedIn. You're the experts on blogging. And if you can comment on some of the things that you've heard in today's webinar, just say, I went to this webinar, it said, and we learned. I think once you do that, you're teaching yourself and you're teaching everybody around there. Engage with your arbitral institutions, starting with C.Arb Kenya, NCIA, and because global funders are scouting for Africa-based talent, just put your name out there. The more third-party funding becomes mainstream, the more likely that you'll also be able to benefit personally, financially from this new and growing area. Just make a target to yourself. To become an expert in any area, all you need to do is invest 10,000 hours. I know 10,000 hours sounds like a big number, but just ask yourself, what are you doing this Friday? What are you doing this Saturday and Sunday? And I can assure you, you can make that 10,000 hours work for you if you just reorient your attention. I speak to you as I speak to my daughters. They are Gen Zs, and I know there's a seed of something of what I say that you will retain, and that in the future, when we look for experts, we'll be looking at Kenya third-party funding experts, and that person could be you. Thank you.
Thank you so much, Emerita Chair, for that. We've come to the end of our presentations. I would like to ask, I think she's covered absolutely everything in terms of what young practitioners can expect to achieve in the future as third-party funding experts. So if I could just take 2 questions, I'll restrict myself to 2 questions from the audience. And then with that, we shall have come to the end of our session. Just 2 questions, please. You can post your questions in the chat. That's also absolutely fine. I'll just read them out. Well, if we don't have any further questions, then I think we've come to the end of our session. It's been very insightful and lively, and I think there have been a lot of insights that have come out from this session. I would like to particularly thank the panelists. You guys are very busy people, but you made the time to just come and share your knowledge and your passion for a very fast-growing, unimagined practice area in our local jurisdiction. I really hope that your insights have, touched someone and led someone in the right direction towards developing a career in third-party funding. There seems to be one question in the chat, which I think I should just read out. It is from Itoto Echakara. and it says, what if any would there be tax obligations and implications? I don't know if that makes sense. The tax obligations and implications in TPF. I don't know. Does that make sense to anyone?
Okay. Yeah, this is what I'd probably say. For the client, once assuming that they have been successful and there is some money coming through to them, I believe that when it comes to taxation, and at least Kenya's taxation framework, then it doesn't really matter. Whatever income is earned in Kenya is subject to tax. The only question is it going to be income tax? Will it be capital gain tax? And maybe those are the questions that will be of concern. But I think anybody in finance appreciates that whether it's damages, whether it is legal fees that has been earned, then that one is definitely subject to taxation in the ordinary way. Contingency fees are problematic for the reasons that Senior Counsel mentioned at the beginning of the webinar. We are not allowed to engage in anything that amounts to contingency fees, but when it is earned, then it does tend to attract tax. So if you are on the receiving end of any benefit that can be classified as income, then tax would definitely be applicable. The only question is what kind of tax and what rate of tax. Most funders are very well versed in any event being in that space, and they would tend to try and minimize the tax burden. They may not extend that courtesy to you as a lawyer or as your client. So you also want to be very careful about how you are categorizing everything that is coming through to you so that you can ensure if it is services that the withholding tax is paid, and if it is just the corporate or income tax, it is paid in accordance with the with our tax regime. When it's cross-border, Africa, we tend to have, if it impacts your income in one of the East African countries, ask yourself if, and I think the biggest question is, Kenya is signatory to several double taxation agreements. If you find that you have income that is accrued in a country where we have a double taxation agreement, then you also want to claim relief on the basis of the double taxation agreement. Make sure you abide by what it provides. So that is a very high level summary. I would recommend that you see a tax consultant on any question that may be impacted regarding to that.
Thank you so much, Emerita Chair. I think I saw another hand up, but it's suddenly gone back down. So unless we can see it in the next 30 seconds.
It hasn't gone back.
It's Peter Wanyoike, it's still up.
Oh, Peter Wanyoike.
Thank you very much.
Yeah,
yes,
go
thank
on.
you,
Go on.
team. Very insightful knowledge. What I heard is that both C.Arb and NCIA have got probably the key towards entrenching that party funding in this country. Now, what I did not hear is whether we're going to have a purposeful engagement for the two bodies to craft all these rules, input what the knowledge and the rules and the regulations that we can have that party funding entrenched in this country. So that's, but commenting on the same, remember in the construction industry, in land, both in the land matters in our communities, we have third-party funders. It's only legally that then it needs to be put into where it belongs. Thank you.
Thank you, Peter Wanyoike, for that input. I don't know if any of the speakers would like to add on to anything onto what he has said before we wind up.
Let me just offer a very quick answer. Peter, as I think we said right at the outset, and I don't know whether you joined at the outset, we said the necessary amendments need to be made to legislation, both the Arbitration Act as well as the Advocates Act, to entrench third-party funding as part of our legislative framework. And then the regulations will follow. I'm certain that NCIA and the Chartered Institute can collaborate in framing those regulations. As always, there has to be public participation, stakeholder engagement, as well as, of course, benchmarking with various jurisdictions that have adopted third-party funding. So regulations will follow the statute. With respect to the prior existence of third-party funding, I started off by saying that actually, in our engagements every day in our legal practices, we actually do engage in third-party funding. We don't call it that, but when you carry a client's case and agree to postpone payment of your fees, you're actually, in a sense, engaging in third-party funding. And so you're right. It is part of our daily interaction, and it is already part of our economic reality. So that would be the answer that I would offer.
Thank you so much, Senior Counsel, for that. I think we've come to the end of our discussion, our session this afternoon. I would just like to read one chat from one comment from the chat by Ms. Akwi, which says, very interesting discussions. A big thanks to all the speakers. You guys have done well, and we really thank you for all the insights into this emerging topic. And it's my hope that, there's a lot of light that has been shed, and we shall be seeing more young practitioners coming into the space of third-party funding. So thank you so much, Senior Counsel Ohaga. Thank you so much, Chair, Emerita Chair. Thank you so much, Counsel David Onsare, for your contributions and your time in this session, and we really appreciate it. So with that, I would like for us to end the conversation. And yes, thank you so much.
Thank you very much, Colin, and thank you, Jackie and David. Very interesting sharing this platform with you. Thank you.
Yes, myself immensely too, Senior Counsel, David and Moderator, and thank you for the incisive questions and also the participation of everybody who's online. Yeah, see you next time. Thank you very much. Asanteni sana. God bless you.
Asante sana, Moderator. Asante SC. Asante Emerita. Thank you very much for taking time to avail yourselves for this conversation. I look forward to meeting you.